it.
Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome to Talk Law Radio. I'm Todd Marquardt here with Kirk Harrison talking about the definition of proper estate planning. And we just got through talking about the first part of the definition, which is when we're alive, we want to take care of us and control our property. And if we become disabled, we want to take care of us and our disabled loved ones if we become disabled. So sometimes we have a family member that is dependent on us for financial support, whether that's a minor child or a child that is independent at one time but has some struggles with life, and you have to help them out after that for some period of time, or if you have a disabled child. The first question comes up as to how you want to structure your plan. If I become incapacitated and somebody else is dependent on me for financial support, do I want to cut off that support, that financial support, because my expenses are higher?
Right.
Or do I want to keep financially supporting them even though my expenses are going up? So if you're doing permission slip planning, this is where people get confused. The agent under durable power of attorney will come into my office and say, I've been named power of attorney, now what do I do?
But let me ask you something. Right? You said durable. What does that mean if he's a durable power of attorney instead of just an attorney showing up?
Good question. There's a couple different power of attorney documents, and one of them's durable, and the durability of it came about because in the old days you could only name somebody as your agent, and your agent only had power to act for you so long as you had capacity. If you lost capacity, if you could no longer mentally make decisions, then your agent lost his authority to make decisions for you also. But the law changed so that the courts would stop being overrun with guardianships, and the law then allowed the agent to maintain his authority to make decisions even though the principal decision maker had lost capacity. So that's the durability of it.
Okay. That makes sense.
But it's a great question, because then the very next question after that would be, when do you want your power of attorney to be effective? Do you want it to be effective?
So there's certain points in time. Okay.
Right. Do you want it to be effective immediately, even though you're still healthy and making your own decisions? Or do you want it to be effective only when a physician certifies in writing that you're incapacitated?
Man, I hope my wife's not listening, because I'm sure that she'll get forward and she'll declare me some kind of incapacitated mentally. And next thing I know, she's going to have me sign something, and I'll be living in the doghouse all the time.
Yeah, so the difference is that doctor's certification. But that goes to the durable power of attorney. And that's a permission slip. It's just where you name somebody,
Right.
and then the document will say a list of things that they're allowed to make decisions about. But they don't know really what you would want. You just have to trust that they're going to use good judgment and good sense.
Right.
So you want to pick somebody who's trustworthy. If you use a living revocable trust, on the other hand, you can put instructions in there about how you want your money to be spent. And so I call that the take care of clause. How I want you to take care of me when I'm disabled and incapacitated. And so in that section of the trust, you can have any number of beneficiaries even while you're still alive.
Okay.
You can have yourself and your spouse, and then maybe those financially dependent children or parents even. if you're still taking care of your parents and they rely on you for financial support, if God forbid something happens to you or me, would we still want to take care of that financial obligation?
Let me ask you this, though. When a person, let's say, does pass on, and let's say the wife has some type of power or anything on it, when she remarries, does that overcome the fact that wouldn't pass to him? That would just be her, or it would just be the way you instructed still, even though she has power?
There are lots of ways to structure that if you're married after one spouse dies, and I'll talk more specifics about that, but thank you for bringing that up. This is a situation when you're disabled. Most happily married couples would probably want to take care of the healthy spouse. In Texas, because of community property, most people share a bank account, for example. I run into some that have separate accounts, and then that's when you would want to decide, is my spouse going to be the person that has access to my separate account? Because you could name somebody else, an adult child, a friend, or other family member to take the place of the spouse. That might put you in the doghouse.
Yeah, that's going to cause a little bit of tension, I can tell you that. But thank goodness my wife already controls all my money, so I don't have to worry about that.
But it's important to name somebody you trust anyway.
Right, I would understand that, yeah. Families, I notice if you appoint a family member now, because of the fact that, people have been known each other since the beginning, okay? And it always seems like when I read about after something happens like a disaster where a family member dies and all, man, they change, it seems, almost completely, So something like this really helps you out, okay? Because a family member might not be the person that's what they would say you're too close to it, okay?
Yeah.
So sometimes choosing a friend that you have met over the course of many years and reliable, man, you might want to consider that, because he's got that, that far away look, okay, that 360 look that maybe family members and all that are too close to it didn't see. So, when you're considering that, I guess that's one of the points that you would point out. Hey, you want to really consider, who you're choosing.
Right. I guess it's a psychological thing when there's a tragedy in the family, and there might be some deep-seated resentments that have been growing. I listened to one attorney at a seminar. He said, you estate planners have it easy. He said the divorce attorneys have it easy. They knew their spouse maybe 5, 10, 20 years. But the sibling rivalries, they've hated each other for 40 50 years.
That's right.
By the time their parents pass away and they get to fight over it. So you could name a bank to be a trustee, and then you take all the family out of it. And what I tell my clients is I'd rather the bank steal from me than my own family.
Well, because they're so good at it. Heck, why not name the IRS? They're the best in the world at taking your money.
Yeah. Well, so going back to this disability take care of clause provision, you could put these beneficiaries in order of priority. So you could say me and my spouse equally at the same time, and if there's enough, then to provide for our financially needy children or our financially needy parents. And so it gives the successor trustee, that friend that you've named, a little bit of discretion to decide what's financially prudent, to budget, take care of who needs to be taken care of, and to stop the financial support for those when it doesn't make sense.
Right.
Another question is, do you want to keep giving to charity? If you've given to your church or charity your whole life, this is another clause that we can put in this disability section.
Yeah,
and
you talk about that, it makes me think of we have a cat that's a polydactyl. They actually have thumbs, workable thumbs.
Really?
They can actually grab things.
Like a raccoon.
Yes, but the thing is, the author down in Key West, who we all know, all right, dedicated a whole house to those cats. The whole house is full of the cats.
I'm glad you brought that up too, because I've been thinking of creating a pet trust for my dog Lexi.
That's
because she's going to need to continue her agility training if something bad happens to me, and she will need to have a place to live. And I don't know which of my children will take care of her the way that I did.
Right. The way you're talking, I don't see it happening, but yeah.
So in that case, you have a trustee who's going to be in charge of the money for the pet, and then you can have a separate person that's the caretaker. Mm-hmm. So depending on what someone's gifts and talents are, you could separate the money from the care, and then the caretaker would just ask the trustee to pay for the vet bill or the food or whatever. Right. There are some circumstances where pet trusts have been revised by the courts. Even Texas law says that if there's too much money in a pet trust, some of that money can be reallocated. So you want to talk to an attorney about getting those things right. We got to take a break, so stay tuned. We'll be right back.
Thanks.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the Ten Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.